We're going to call a meeting to order. We're a few minutes early, and I appreciate that. The notice of the July 11th, 2016 meeting, the Real Estate Appraiser Commission, was posted on the Real Estate Appraiser Commission website on June 17th, 2016. We'll call our meeting to order. I appreciate all of you being here. For those of you that don't know, we do have two new members. We're glad to welcome Mike and Rex. You'll have to speak in. If you have something to say, you'll have to speak into your microphone instantly. It'll come on. Eric, we'll start with the experience interviews. I know we don't have a vote, but do you have anything to discuss? Oh, I'm sorry. Need to have a roll call. It says experience interviews are first. All right, we'll do a roll call. Just start with Mike. Go ahead, Mike. Just introduce yourself. Tell you where you're from.
My name's Mike Tankersley. I'm from Lewisburg, Tennessee, and it's a pleasure to be here.
Fred McCara, Johnson City, Tennessee.
Rex Garrison, Gray, Tennessee.
Randall Thomas, Kingsport, Tennessee.
Eric Collinsworth, Arrington, Tennessee.
Norman Hall, Benning. Norman Hall, this city.
All right.
Norman, glad to have you back.
Yeah, here.
Yes, sir.
All right, Eric, do you want to talk about, even though we don't have a vote, your experience interview?
Yes, I had a trainee 500-hour interview with Chris Allen Hodge this morning, and had a very good conversation with him. I think Mr. Hodge has a very good grasp on the principles, procedures, methodologies, and I definitely feel confident that he's going to do good for the industry.
Good, it's good to hear. I also had an interview, but it was canceled. And I guess we'll do that at our next meeting. I would like you to review the minutes. They're on your iPad.
Mr. Thomas?
Yes.
Could we have a motion and a second to adopt the agenda?
So moved to adopt the agenda.
I'll second it.
All those in favor say aye.
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 All those opposed?
Thank you.
All right. Please review the minutes. They're on your iPad. Anybody have any questions, additions, or subtractions? Any longer?
I would vote that we approve the minutes from the May meeting.
Motion on a May meeting. Do I have a second?
Second.
Second to approve the May minutes. All those in favor say aye.
Aye.
All those opposed? Thank you. Minutes are approved. Dr. McCary, you want to give us your opinion of the education report?
Yes, I reviewed 7 courses and 4 individual course applications. They all met the qualifications for approval, so I recommend approval of the 7 courses and the individual courses.
All right. Anybody have any questions about those?
The only question I had is in regards to that Appraisal Institute course, reviewing the appraisal process. Is there a course number that's been identified for that one yet? I didn't see it on the list.
Appraisal course, what's the
Reviewing the appraisal process. It's the last one on our list down there at the bottom of that grid. It's an Appraisal Institute course with Mr. Sellers as the instructor, but I didn't see a course number. I didn't know if they'd identified a number for that course yet or not.
I don't know if there was a course number established for that. Ms. Avers, do you know anything about that, whether there was a course number established for that?
I assume they would
I
have
don't
it.
see reviewing the appraisal.
Yeah, it's
Last
July.
one.
That's the last one. You're not looking at the May one, are you?
Get the revised.
Yeah, the revised one. It's not on the iPad. It's
okay.
on the.
Yeah.
Dennis
It's on
should
the
have.
printed
Yeah,
sheet.
that one
I
came in
apologize.
like on Thursday of this week. Let me see if I've got it.
Probably 1939. If it just came in, it gets assigned the
That'd be maybe
subsequent number.
1945 or something possibly. Okay.
45.
I didn't see it on there yet.
Let's check, see if there's anything on,
Those
a
are
hard copy
auto-assigned
that
when
I
they're
have.
approved.
excuse me?
The course numbers are auto-assigned when we put them into the computer system.
Okay.
All righty. I just have a question about the first one. Mike, is that you on that first instructor?
Yes, it is.
Okay. 5 is a quorum, is that right, Nicole?
Yes,
Okay.
although only.
I'm on it also.
Oh, I didn't see that. Okay.
It's,
Like past you.
you only have to have quorum for the meeting. Beyond that, you just have to have a requisite number of persons to vote. So if
Okay.
if you both recuse, you can still hold a vote.
Okay, we're gonna vote for everything except the first one. Thus, Mike, you and Rex can vote. So we're gonna vote for everything except the first one.
Excuse me, Mr. Chair, I need to recuse myself on the last one, too, Mr. Sellers, since I am the chair of that education committee for the Appraisal Institute for the chapter.
Okay. We're gonna vote on 1921, 1922, 1942, and 1944, and 1938. All those in favor of 1, 2, 3, 4, 5, please say aye.
Aye.
Any opposed? All right, we're gonna vote on the first one, 1925. All those in favor say aye. Aye. All those opposed? Okay. Now we're gonna vote on the last one, reviewing the appraisal process. All those in favor say aye.
Aye.
Opposed? All the courses passed. Now we'll vote on the instructors at the bottom. Anybody have any questions on those?
Do we have motions and seconds on these? I know the vote was unanimous, but officially, do we have somebody motion and second?
I'll move we
But I
accept.
thought it came from a committee, it didn't require that.
I could be wrong.
I recommended approval. That,
Okay,
I know that could be interpreted as a motion,
okay.
but I don't know if it was a second or not. Anyone want to second it?
I'll second it.
All right, then we have it officially. Thank
And the
you.
vote stands, okay. All right, let's go down to the individual course approvals then. Do I hear a motion that we accept those 4?
I move that we approve.
Okay,
I'll second that
all
one.
right, motion's been made and seconded. Any questions on them, discussion? All those in favor say aye.
Aye.
Any opposed? Those are approved also. Thank you, Dr. McCary. Do you have anything else?
No, sir.
All right, thank you very much. Appreciate your time. Director's report, Ms. Avers?
Second.
Can't do that.
This is my last director's report. As you can see from the information in the director's report on your iPads, I've written a summary. It's been a very rewarding and at times challenging 10 years here with the state. I've certainly learned more than I could repay about leadership. We have made major accomplishments together in improving the regulatory process for real estate appraisers. I could probably list a dozen things that have changed in the last 10 years, and all of it to the betterment of the real estate appraisers. I sincerely feel this board has met its mission to protect the public welfare by ensuring that only qualified persons are licensed or certified, and that all licensees uphold the highest appropriate professional standards of practice, independence, and competency. So I think I'm leaving you all in a very good place. Regulating the appraisal management companies, AMCs, will bring new challenges for the next director as they work through the legislative changes necessary to meet the federal requirements, onboard the requirements to the National Registry, and effectively enforce the requirements of the Truth in Lending Act and state law. I'm leaving on the cusp of many new successes for this program in efficient and effective government, including online applications and a customer service system that monitors the program calls and reacts dynamically to frequently asked questions. I'm excited as I begin my next chapter here with the appraisal management company, DART Appraisal, and I hope you all will continue to support me as I move into the next phase of my career. And that's all I can say without getting all wishy-washy, so that took everything out of me. Of course, the budget information is included, as always, for your review. The May information shows the budget plan for the year of $482,900, total expenditures of $289,829, and thus far for the year, total revenue, $714,968. Estimated costbacks for the programs, administration, and legal costs have not yet been applied. That's why our expenditures look so low. This is an estimation, not a verified fact just yet, but they're estimating our costback charges to be approximately $117,545. Next year's legislative proposals and the legislative update for this meeting. Legislative proposals for next year's consideration have been submitted regarding the federal minimum requirements to have appraisal management companies participate in federally related transactions. Arrow and several appraisal organizations have been seeking clarification from federal agencies as to which transactions are meant to fall under federally related transactions. A clarification is essential for states to properly enforce Title 11 of FIREA. The FDIC's recent narrow interpretation of the term is actually a reinterpretation that is contrary to the letter of the law and the intent of Congress when it was enacted. That's an opinion for it, that Arrow has and several other agencies. John Russell and Peter Barash have contacted persons at government agencies which have come to rely on Title 11, all to encourage their involvement in getting the bank regulatory agencies to interpret FRTs very broadly and properly. In this regard, ASA has prepared a white paper which details the objections to the FDIC's interpretation and explains why it's wrong. I've attached a copy of their white paper for your review. It was transmitted officially to various interested parties with a cover letter from ASA and NAIFA, the National Association of Independent Fee Appraisers. The white paper written by these two interest groups has been attached for your reading enjoyment and to keep the commission well informed. It's not, you don't have a call or need to vote on anything at this time, but I thought it was important that you be aware of this issue that's ongoing. And I'm going to conclude the rest of this and then I'll open it up for discussion. When thinking about 2017 legislative proposals for real estate appraisers, please keep in mind that legislative proposals should generally affect one of the governor's priorities: education, jobs, efficient and effective government. Also consider whether or not the intended outcome of the proposal could be accomplished by rule. If the commission has any other legislative proposals, please remember the department evaluates agency proposals based in part on one of the following criteria, or all of the following criteria. Does the proposal align with the governor's vision for the state? Does it help advance his priorities or make improvements to those areas? Is it good public policy? How does the proposal interact with other suggested bills from the agency? Does it cost the taxpayer money, or is there a fiscal impact? And is a change in law necessary to achieve the desired outcome? We discussed this briefly last time, but I wanted to make sure I gave you a second opportunity to discuss this. Administration will put forward legislative agenda that contains a limited number of bills. Anything proposed should reflect the highest priorities of the commissioner and the governor. And with that, I turn it back over to you, Mr. Chair.
Any discussion on it? Mike, you or Rex want to have any questions? Anybody else?
I'm kind of interested in seeing
Except
where
Eric.
this. I'm kind of interested in seeing where this is Title 11 of FIREA's definition of federally related transaction is going to go. Is this something that we're going to be kept up to date on as far as interpretations back and forth between the federal agencies and what everyone else in the industry thinks that they are? Or?
I don't know, Mr. Collinsworth. My last day is Friday, so.
I guess as far as following it, you know, that now that there's a white letter that's been produced on it, a white paper, do we just wait to hear their rationale behind it? Is this something that the federal agencies maybe will be? Hey, have you guys heard about any of this other from discussion, Mr. Thomas?
There's about 5 or 6 different definitions out there, the way I can understand it, of what an FRT is. So I don't know whose we're going to buy into or which one we're going to use. So no, I don't know anything different.
If, you know, just to, I see if I can capture it briefly for anyone who may not be familiar with this topic. There were several issues that came up all at once, including Appraisal Institute's alternate standards, including the appraisal management regulation where states could opt in and out based on whether or not they wanted to have AMCs be able to, over the definition of 25 on their panel, participate on the National Registry in federally related transactions. So, okay, how does the regulators, this was a discussion at Arrow, how does the regulator determine which of the transactions are federally related? And it became clear from discussions that even the regulators couldn't agree on what is and is not, by definition, a federally related transaction. And we invited the speaker from the FDIC, and the FDIC came and they said, well, only about 12% of all transactions are federally related. And then later she said, and if the de minimis level goes up, then only about 4% of transactions will be federally related. And that kind of shocked the regulatory room because most of the regulators in the room had been operating under the assumption that all of the Fannie Mae, Freddie Mac, FHA, VA, all of those regular secondary market and government-sponsored enterprise agencies were included in that FRT definition under certain protections that Title 11 ensures. And the FDIC is apparently not of that opinion. So that opened up the wide opportunity for states to opt in, opt out on federally related transactions. That also kind of gives a backwards perspective of, well, we've been licensing real estate appraisers for 20 years, 25 years. How much of that do we actually have to do? So the appraisal subcommittee, a letter was sent to the appraisal subcommittee asking them to please clarify, since all the major organizations, there are 6 organizations that make up the appraisal subcommittee's board, and we asked them to please clarify it and define FRT for us, what is and is not. And a year passed, and they hadn't responded to the letter, despite the fact that they discussed it at every meeting. They haven't officially opined on the topic. So a second letter was sent to them from Arrow after a year, essentially pushing it, asking, you know, we've waited patiently for a response. This is becoming imminent with the AMC legislation coming in. States need to know what is the official definition that the appraisal subcommittee is going to hold us to. And then shortly thereafter, a couple of the independent appraiser organizations have stepped in and started talking to people in Congress, and they're up on Capitol Hill saying, look, Dodd-Frank and all of that, there was like some major assumptions that these types of loans would be protected loans, and they are not considered, according to the FDIC, protected loans. So there's a lot of tension in the market on this topic. So I wanted to make sure that this board was well informed on this topic, because probably unless you attend the Aero meetings, you will not be able to stay up on this kind of stuff.
Thank you. On your executive summary, can we get a copy of that sent to us
It was emailed to you.
again?
All right, I will.
Okay. Anybody have any further questions? Our legal report, Ms. Matthews.
Thank you. For our new members, basically what I do is I'll read the complaint number, let you all read over it, and then you can ask any questions and vote on the recommendation. So our
Page.
The legal report's a separate, you'll have to go back out.
Okay.
yeah, click on library at the top left, and then click legal report.
Everything, didn't you? I'm sorry, touch it soft.
There we go. I'm too manly.
That's what I've always said about you.
Here we go.
There it is.
I'll share with you.
Copy of the legal report?
Copy of legal report, yes.
Let's see, I found my,
You are in the internet.
My paper copy.
where, I couldn't figure out where, there it is, okay. Okay, thank you.
You're already there?
Everybody there? All right, Ms. Matthews.
Okay. Number 1, 2016-000-161.
Everybody had a chance to read them? All right, Ms. Matthews, continue.
You guys want to adopt them one by one or as a whole?
Yeah, we do them individually.
Okay. Do you want to discuss my recommendation for the first
Yeah,
one?
that's what I want you to do, yes.
Okay, so my recommendation on the first one was, the reviewer found that the inconsistencies throughout the report diminished the reliability of the report, and there is not adequate support for the conclusions rendered. As such, council recommends the authorization of a civil penalty in the amount of $1,000 to be satisfied within 30 days of the execution of the consent order. Such terms to be settled by the consent order or formal hearing.
All right, hearing a recommendation from council, any discussion?
Would it be advisable also to require a course or more for this individual, report writing, so forth?
You're at liberty to make any adjustments that you wish to this. This is one individual, right?
Yes.
Okay. Dr. McCarroll, any recommendation?
Just, of course, you guys know better what ones are available for, use in this particular case, but it seems to me something about report writing would be, or on making comparables.
Is the residential report writing, that's a 7-hour course, I think, is that correct?
There
Or is
is
that
a 15.
15.
The residential report writing case studies course is a 15-hour course. There are some other. I don't have that list with me.
I'm kind of torn between that or the sales comparison approach, but
I think that might be the better choice, as a matter of fact.
Sales
Commissioner
comparison
Collinsworth.
approach.
Yes, sir.
Okay.
I recommend the civil penalty in the amount of $1,000 along with the sales comparison approach course.
Second.
Is that the 30-hour?
There's also a shorter one of those, I think. Is there a 15 or is it the full 30-hour? If not, then I'm behind the 30-hour one as well. I have some problems with the errors that were found, and then not only that, the respondent's response. The respondent's response says, as a result, the comparables used in the appraisal may not have been the best choices after a long and thorough search. However, the respondent states that under certain circumstances, the comparables used were the most similarly situated homes and residential properties available upon reasonable search. Well, due diligence doesn't necessarily mean you stop at a reasonable search, and you may need to go ahead and do the long and thorough search if that's what's applicable for the property type. Or for the assignment. And it's almost contradictory right there in their own response. So if that is only a 30-hour course, then yes, the 30-hour sales comparison approach.
Anyone else? We have a motion and a second on the floor to impose a $1,000 fine.
And that would be to be
And-
satisfied within 30 days,
Right.
the fine.
And the fine will be satisfied within 30 days, and the sales comparison, 30-hour sales comparison approach. Any further discussion?
I'm sorry, Mr. Chair, who was the second on that one?
McCara?
Thank you.
And on the courses, that's 180 days, correct?
Yes.
Okay.
Yes.
Fine is 30, the course is 180. Okay. Everyone understand what we're voting for? All those in favor say aye.
I had a question. I'm
Oh,
sorry.
I'm sorry.
Is $1,000 a minimum? Because, the reason I say that is because the original was 1,000 and they were adding a pretty expensive penalty. I didn't know if that's possible.
The civil penalty, you can, go ahead, I'm sorry, Mr. Stone.
The civil penalty, yeah, can be adjusted.
It's up to $1,000, so.
Recommending education, it means they can get better. So this wasn't really the maximum that we should be. This is kind of what I'm getting at. It's going to
Sure.
be, once you add on the other, you're kind of doubling it up, that's all I'm saying. So I would suggest lowering.
Okay, we have a first, we have a motion and a second on the floor for $1,000 penalty and a sales comparison approach class. We need to either vote that up or vote that down, and then we'll
Yeah.
hear your motion. All those in favor of the $1,000 and the sales comparison approach, say aye.
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 All those opposed?
Aye.
Aye. Okay, so it's 3 to
Sure.
2. All right, motion fails. Let's go back to the motion. Mike,
I
Mr.
would like to
Tankersley.
amend the motion to be
Sure.
$500
All right.
instead of 1,000 and still do the education requirement.
Okay. Motion's been made to lower the penalty from $1,000 to $500. Do I hear a second?
Second.
Okay, and we're going to keep the sales comparison approach with it. We have a motion and a second for a $500 civil penalty and the sales comparison approach. Any further discussion? All those in favor of the new motion, say aye.
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 All those opposed? Motion carries. Number 2.
Number 2, 2016-01-3561. Ready for the recommendation?
But wait a minute, everybody had a chance to read it? All right, yeah, the recommendation, Ms. Matthews.
Council recommends a letter of instruction pertaining to SR 1-4A and 1-6A.
All right, you've heard the recommendation from legal counsel. Any questions? Comments?
I might just, for the new members, letters of caution, warning, and instruction are not considered disciplinary action. They're informative, however, they are retained in the record as unproven matters, and it can be considered in future cases if there's pattern or whatever. But they're not disciplined. They've not been held, found guilty of anything. It's just a warning or an instruction about certain provisions of standards or laws or something like that is all a letter of instruction is. I just wanted you to both be aware of that what those are when you recommend a vote on those.
Thank you, Ms. Avers. Any questions? Ready for the vote? All those in favor of council's recommendation say aye.
Aye.
Aye. All opposed? Thank you. Number 3.
Number 3, was there a motion?
I have a motion and a second on that one.
Oh.
All right.
Thank you. Motion, we have a second?
All right. Thank you, guys.
Number 3, 2016021311.
All right, that's a short one. Go ahead, Ms. Matthews.
Council recommends a civil penalty in the amount of $1,000 to be satisfied within 30 days of execution of the consent order. Such terms are to be settled by the consent order or formal hearing.
Any questions on the council's recommendation?
Move to accept.
I have just a question, please.
Oh.
Is the disciplinary history the same or a different item as what we're talking about now? Excuse me?
Very similar matter.
Okay. Any discussion, on the council's recommendation? Go ahead, Dr. McCarron.
Move to approve.
Okay. We have a motion to approve council's recommendation. Do we have a second?
A second.
Second. Any discussion now?
The only discussion I have would be back to the fact that it was a similar, it's been noted that it was a similar incident. And back then on the first one, it was a $1,000 penalty and a 45-day suspension. I don't know if that's something we should consider. You have to ask yourself how many appraisal reports were written or signed by this appraiser while their license was expired. That's to me sounds pretty severe to be out there signing reports if your license is expired. And I'm assuming this was probably about the same time, 2012. But they've already been fined once, $1,000 and a 45-day suspension. I didn't know if we should consider that.
Chair, if I may?
Maybe we need to.
Just to possibly help with the discussion. I believe that, yes, this conduct was in that same period of time. But it was a different appraisal report than the first complaint.
But it too was about not being licensed. Okay, so I guess my question that I would have to say is, how many out there has been signed that haven't had complaints filed on them? That's the other thing. So, we're never going to know that, but it would seem, we're never going to know that, but it would seem to me like the 45 days didn't do much good.
Well, the conduct was already disciplined back in 2012. It's now 2016. So, but somebody else apparently noticed a complaint.
I do see, I guess since then, because it does say that their license is now effective through February 12th, 2018. So I would assume that they have kept it in good standing since then?
Yes.
Okay.
My question would be, are we punishing them for the same thing a second time?
Right, that would be the only reason that I would not want to push for the suspension, because it was something that happened 4 years ago. And if their license was renewed and then has been kept up since then, that was the reason I was asking that. Then I don't feel like that we would need to suspend them any further.
That's That is also what our thinking was with
Right.
regards to not
Right. I
including
mean, it's
another
happened 4 years
suspension.
ago, and, yeah. The only thought of that would be is if they end up finding 7 more appraisals from 2012, this is gonna be it could potentially end up being a pretty hefty fine down the road if we find more, but I think we have a motion to accept and a second maybe already.
Don't
Let's
have a
go ahead and
second
vote.
yet, I don't think.
Oh, we don't?
Mr. Tankersley made
And I
the
would
second.
almost want to amend that, because I kind of feel like we're, we kind of gave him the death penalty at the first, where we gave him, gave him 1,000, and then we gave him 5 days, so we really hit him hard. And this is, in essence, basically the exact same thing that we're penalizing him for, and I kind of almost want to say he's already been penalized for it, so I'm kind of want to withdraw my motion to accept.
Do you have an alternative? You want to propose an alternative?
I would say we would lower the fine to a minimum and recognize that this was a mistake and that this may have multiple reports coming. But I think he did get the first fine at 1,000 and the 45-day suspension. I think that was pretty severe.
I don't know if we have a minimum, do we? I mean, you just,
50, I think, is the minimum.
50. I can double check that.
It's 50 to 1,000 per violation per day.
I would make a motion that we do $100 instead of 1,000.
Okay. On number 3, motion,
Did McCarra withdraw his?
Well, I think it dies for lack of
it
a
dies, we
second.
did lies
Okay.
of a second, yeah, lack of a second.
All right, thank you. I just want to make sure.
Yeah. Okay, the motion's been made to amend legal counsel's recommendation. Do I hear it to $100? Do I hear a second?
Second.
Okay. Motion has been made, and we have a second to make the recommendation $100 instead of $1,000. Any further discussion? All those in favor say aye.
Aye.
All those opposed? Motion carries $100. Number 4.
Number 4, 2016021231.
Can I ask you a question while we're reviewing this? In the second bullet point under respondents' response to allegations, is that a typo there? No, I'm sorry, I was reading it wrong. Never mind. No, I do want to ask that. It says certainly noted located. Is that supposed to be certainly not located instead of noted located?
I believe you're correct on that. I think. What were they saying?
All right, if you've all had a chance to read it, before we discuss it, let's hear legal's recommendation.
Council recommends the authorization of a letter of warning in regards to the above referenced USPAP violations and 30 hours of courses, a 15-hour residential site value and cost approach course, and a 15-hour residential report writing course to be completed within 180 days of the consent order.
All right, you've all heard recommendation from council. Do you have any discussion? Hearing none, do I hear a motion to accept recommendation from council?
Motion.
Motion's made. Do I hear a second?
Second.
Motion made and second to accept council's recommendation. All those in favor say aye.
Aye.
Any opposed? Carries. Thank you. Number 5.
If we could go back to number 3 really quick,
No,
please.
sure.
In the consent order, would you like me to add language that essentially says, because you have been previously punished for the expiration of your license, this is essentially why we decided to go with the $100 minimum?
Put something like that in the letter?
Yeah.
You know, I would not like to put that in there personally. I just think that draws a precedence for other people who might say, well, you know, you did it for him, but you didn't do it for me at some point in time. So I think I would be of the opinion not to put that in there.
Standard language that we normally use.
Please.
My thinking on that is that when we send this out, the complainant, which is a completely different complainant, is going to get a copy of the consent order, and it's going to look like the commission punished an appraiser for unlicensed conduct at $100 with no reasoning or rationale. And that may set a precedent. So, right, I would recommend if there can be because you have already been punished for this time frame of,
I'd say, like, since you've already completed a 45-day suspension.
Sure. I agree with that.
it more than anything memorializes the fact that he's already been punished for the same conduct, so that the complainant doesn't think that we just,
During that same, I would emphasize during that same time
Time
period.
frame, yeah.
On the effective date of the appraisal report.
right, it's a different complainant entirely, so they
Right,
won't they won't know about the history.
Right, I don't have a problem with that.
Through number 5 now.
Number 5, 2016022691.
They had enough time to go through this? Go ahead with the recommendation, Ms. Matthews.
Council recommends the authorization of a civil penalty in the amount of $5,000 to be satisfied within 30 days of the execution of the consent order. Such terms are to be settled by consent order or formal hearing.
All right, the commission's heard the recommendation from council. Any discussion? If, Excuse me?
Go ahead.
If not, do I hear a motion to accept council's recommendation?
I have a question. What about the history of his penalties?
Go to number 5, it'll be on there, right below his name.
And I don't-
Disciplinary
But I'm just
history.
kind of
I don't have
figuring-
any detail on
That's kind of
those.
what I was asking about.
Okay, I'm sorry.
Just that
I do.
Nicole should have the
You
detail. I think
elaborate.
she.
I tried to include at least some of the information on these. Just real quick. That's why I added a little bit about what they were disciplined for, and you can see the courses they were disciplined. They previously had to take all of these courses and have done so, of course. And then the civil penalty has gone up incrementally based on this disciplinary history. Obviously, I had some serious concerns about this one, and that's why, despite the fact that we've had significant history of report development and writing issues, which is demonstrated by the types of discipline assigned to this appraiser, it doesn't seem to have stuck, is my personal opinion. The reviewer's conclusions indicate that this appraiser is either negligent or incompetent in performing this type of appraisal. The review stands for itself, and that's why a higher civil penalty than average is recommended, basically because it's a cumulative pattern of discipline.
Anything else?
I'm just curious if that's enough of a penalty. I know I think it's as high as you can go on the civil penalty, maybe, but
I don't think it is, but it is per violation per day, so you could
Okay.
go
I
one for
gotcha.
each violation, but that's the commission's decision.
2 appraisals involved in this. There are, yeah. I don't know, it almost appears as though taking courses are not helping. I mean, we've taken appraisal of income, producing properties. I'm assuming that's the longer use PAP, highest and best use, sales comparison techniques, market analysis. I'm assuming that this appraiser must have a trainee now, as they've taken the trainee and supervisor course, residential report writing, and case studies. And still faced with this now, so.
Am I mistaken that those courses were taken around 2000 based on those numbers?
Yes, that would be correct. Like the 2000, 2001 timeframe.
It's been 15 years since
Oh, yes.
the education.
Since they've taken those
Since that
courses,
first one, yeah.
the barrage.
I think it closed in 2002,
Yeah.
and then the other ones closed much more quickly. I took over as director in 2006, so I have more familiarity with the last 2.
Further discussion or other recommendations? I can't, do we have a motion and a second yet? I don't even
No.
remember.
No, sir.
Okay. Do I hear a motion on council's recommendation of the $5,000 fine? Okay. We have a motion. Do we have a second? To die for a lack of a second. Postpone this? Take an action? I don't know what to do if we don't have I mean, we can, does anyone have any other recommendation? The motion's gonna die due to the lack of a second. So, let's go back to the table then, gentlemen.
I would almost recommend the $5,000 penalty and principles and procedures courses again. Haven't had that one in a while.
Put that in the form of a
Discussion
motion.
I'll move that we, in addition to the civil penalty in the amount of $5,000 to be satisfied within 30 days, we also include the 30-hour principles and 30-hour procedures courses to be fulfilled within 180 days.
All right, we got a motion. Do I hear a second?
I'll second that.
Now we have a motion and a second for a $5,000 penalty and a techniques, is that what it was?
Principles and procedures
Principles and
courses.
procedures, okay. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Thank you, gentlemen. 6.
Is that one course or two separate
Two
courses?
30-hour courses.
Okay. So one is principles and one is procedures.
Yep. It's normally taught to trainees.
Okay. Number 6 is 2016022721.
Let's read it. Ms. Matthews, your recommendation?
Council recommends that this matter be dismissed.
I'll move we accept.
Second.
Motion's been made and seconded to accept council's recommendation. All those, any discussion? All those in favor say aye.
Aye.
All those opposed? Thank you. Number 7.
Number 7 is 2016023501 and 2016023502.
All right, Ms. Matthews, give us your recommendation.
Council recommends this matter be dismissed due to insufficient evidence of unlicensed activity.
Commission's heard council's recommendation. Do I hear a motion to accept?
I'll make that motion.
Made. Do I hear a second?
I'll second.
Motion made and second to accept council's recommendation. All those in favor, any discussion? All those in favor say aye.
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 All opposed? Motion carries. Thank you very much, Ms. Matthews. I appreciate it. That concludes the legal report. Before we get into new business, which shouldn't take all that long, should it? But we have some discussion. We've been sitting here for about an hour. Let's take about a 5 or 10 minute break.
Before we go, could we do, we have one applicant review that was part of the director's report that he's been sitting here very patiently.
Oh,
I
sorry.
don't know if he needs to drive back home. If we could just take this matter up real quick, and then the break would definitely be
I don't have
appreciated.
anything on it.
It's on your iPad. You just have to go back to the thing, go back, hit it soft in the middle,
Go back to
go back to the
Library.
library, and then you'll see it says Murphy. And
Okay.
I'm going to just read the review summary for you. Joe Bedford Murphy submitted an application to the Real Estate Appraiser Commission to become certified residential real estate appraiser by reciprocity. The applicant checked yes to 2 of the questions on Section 2 of the application pertaining to ethical conduct and legal history. In response to this, the applicant indicated that in a May 2nd, 2016 letter included with his application that in the early 2000s, he was doing work for many appraisal companies, and one of the companies in Bowling Green was running a mortgage scheme that he wasn't aware of. He indicated that people admitted to changing his appraisals, and he was found not guilty in connection with those matters. Also, the applicant included a letter of good standing from Kentucky, which included disciplinary history and attached 3 consent orders or agreed orders. The respondent did not include a response about this discipline, so staff contacted him requesting a response about his discipline. This included a 60-day suspension from August 1st to September 30th, 2006, not being able to supervise trainees for 3 years, and having his files reviewed for 2 years. This was based on 4 appraisal reports and numerous violations of USPAP. There was also a suspension that ran from March 1st, 2003 to March 15th, 2003, a $1,000 fine and a 15-hour USPAP course, a restriction on to only appraising 1 to 4 family properties for 3 years, and not being able to supervise trainees for 3 years, and having his files reviewed for 2 years, including an experience log requirement. This pertained to 1 appraisal report with numerous violations. And prior to that, there was a graded order when he was required to complete a 15-hour report writing case study course and a 15-hour site value and cost approach course. This pertained to the respondent had violated Standard Rule 1-1A and Standard Rule 2-2B8. Because the applicant was not forthcoming about the disciplinary history and his response, even after a request did not seem complete, a follow-up call was made to the state of Kentucky, and they confirmed that the appraisals had numerous violations and they do not suspend persons for differences of 1.5 miles to 2.1 miles, nor for acreage differences of 0.01 acres. For this reason, we asked for his experience log, a recent experience log, and we selected some reports for those to be audited. Under 1255.01.07 and 1255.06, Part 6. An applicant for licensure or certification meeting the requirements of TCA 4.3.1304 D1 may be issued a reciprocal license pursuant to TCA 6239.322 and Tennessee Comps Rules and Regulations 1255.01.05, 07, and 08. Upon compliance with all terms therein, including application and payment of all fees required for the issuance of such reciprocal license or certification. The director recommends a review of this applicant's experience and prior discipline before his application can be considered for approval. And with that, he is here today to discuss the disciplinary history with you, and he submitted appraisal reports and appraisal update
Okay.
for your review.
Thank you, Ms. Eric. Before the commission makes any comments, Mr. Murphy, you want to make a statement?
I do.
Okay.
First of all, I sent in everything I thought that I was asked to send. I did not withhold anything intentionally to send in. But the second thing, everything that you've seen, these sanctions that was against me was a trial in 2004 for mortgage fraud and wire fraud. It was involved, I'm sure you all were familiar with it, a mortgage and wire fraud scheme in Bowling Green, Kentucky that I did appraisals for. I took that to court, went to federal court with it. I never done any of the appraisals that funded any of the loans. They changed my appraisals. We proved it in court. I didn't do any of that stuff. All this is associated with that situation. They have to, I know you protect the public, and that's what the board does. And Mr. Disney has brought me in and wanted me to do classes for him as far as that goes after this was over. And, no, I wouldn't. But I've been doing appraisals for 10 years since the 06. I've never had a complaint. I've never had anything sent in. That was all. Now, did I do everything perfect back in the day? No, sir. I did too many appraisals. That's what my problem was. I had too many going on. I called the board the other day when you sent your information for me to get because I did not have that information. So I called and talked to Ms. Thomas, and she gave me that information that I give you for the reasoning. She gave me that. She did not have a copy of the last one that I didn't have anything because she didn't have it. She couldn't find it, so that's why I did not submit it. I didn't have it, but I'm a good appraiser, and the reason I'm doing this, I got a couple of local banks there. I live about half a mile from the Tennessee line, and they just want me to do some appraisal work for them. I do some work for them in Kentucky, and they just want me to do some appraisal work for them there in Tennessee, and that's why I applied. You know, I didn't know I'd go through all this, or I probably, to be honest with you, wouldn't have applied, but I do a lot of appraisal work in Kentucky, but that's 10 years ago that something happened, and that did happen. And I took all the classes, I paid the fines they charged me. Did I agree with them? No, but I went ahead and done it because I wanted to continue working, and that's what I done. I went to court, though, as far as all this other stuff goes. I went to court. I went to federal court. I lost my farm over it, but I took every dime to pay for lawyers to prove my innocence, and that's what I've done. And it does hurt a little to bring it back up again,
Sure.
to be honest with you.
The 10 years that you've been doing appraisals, that's in Kentucky?
Yes, sir. I'm also a real estate broker. I'm also an auctioneer. I'm also a licensed insurance and P&C, health and life, which I've I've never had any complaints in any of that. And this is the only complaints I've ever had was that deal going on back then. That was all associated with that court case.
Sure. And now, this audit that Ms. Ayers, that you mentioned, we haven't had a chance to look at those yet?
I submitted them to you with the other board documents. You can choose to review the reports. I think Mr. Collinsworth said he had a chance to look at them.
Had not or had?
I just glanced through them to just
Okay.
see what they were. I have not had a chance to review them all the way yet.
Entirely to the board's discretion. You can see his letter there from May 2nd, 2016, and there's a second letter that he supplied after we asked for information about the consent orders. It should be also in that packet.
Any of the commission members wish to address Mr. Murphy? Discussion on this? Ms. Havers, let me ask you a question. Is it possible to grant him a temporary license?
We already have temporary practice permits. Those are just for one assignment.
For one assignment, okay, no. I didn't know if we could grant him something like 60 days or something until we had a chance to look at this. We don't have anything like that?
Apply on a case-by-case assignment.
No,
with
no.
temporaries, but
Yeah.
no, we can't do
Okay.
a temporary license.
I didn't know, no problem. Any recommendations from the committee?
Just note, it seems like feel like you've paid whatever penalties that were due to you, and you feel like you're being punished over and over again for something that happened a while ago.
Yes, sir. It comes up every time, you have to put that on that's the reason you mark the box yes, and then this comes up, and then, and it's something, even though you're innocent, you're guilty, it's just the way it is. But let me make it easy. If I knew, like I said, if I knew it was going to be this big a deal, I would not have applied to start with. But now I'm hooking it for $550. So, if you feel uncomfortable with me, I wouldn't recommend me. But I would like to get my check back, my $550 back. If you're not, I didn't know that any of this was going to happen. I would love to do some appraisal work just for those banks around local in-house stuff. But I didn't mean to come up here and make a big committee thing out of this thing. Like I said, I'm good either way. I just like to get my money back if that's possible. I've been up here since 8 o'clock this morning.
Is that even possible, Ms. Havers?
Sure, it's possible. If the commission votes for that.
For discussion purposes, I feel like we ought to comply and grant him his ability to practice.
In the form of a motion?
It's a form of a discussion question
Okay.
to see if anyone wants to respond to it.
Is it, the next scheduled meeting is in September, I do believe. Is it a big importance on you to hear something today? Or would it be possible for us to table this and discuss it and let the appraiser members review your reports and then just pick it back up at the September meeting?
With all due respect, and I do respect this board, and I in no way am meaning this, I just soon to get my check back and not go through this again. I mean, it's not that important to me, no. As I told you, I'm doing it for a couple of local banks that are having trouble getting appraisals done, and I do their Kentucky stuff, and that's what I was getting them for. I didn't know I was going to go through this, and I just, if I can, and with all due respect, I'm not, in any way I just soon not even have to go through that again. I mean, I drove up, I've been up here since 8, the guy told me to be here at 8 o'clock this morning. I've been sitting in this cold room since 8 o'clock this morning, and so I'm ready to go home.
So I'm correct in saying that in federal court, you've been found innocent on all this?
Absolutely, and I'll give you the copy of the whole thing. Absolutely, and it took them 12 minutes to do it, but it cost me $50,000 to prove it.
All right. Anybody from?
I would move, since we haven't had a chance to review the reports thoroughly, or have a state reviewer take a look at the reports. If he's willing to say that he's fine with taking his the $550 application fee refunded, I mean, I move we refund his $550 application fee, and if he decides he does want to pursue it, he knows we have this information available, and at that point we can have the reports reviewed at some time and go forward from there. That's my motion.
A motion to refund Mr. Murphy's money back to him. Do I hear a second?
I second.
A motion and a second. Any further discussion? All those in favor say aye.
Aye.
All those opposed? Motion carries. Please refund Mr. Murphy's money back to him.
Thank you for your time. I appreciate
Thank
it.
you, sir. Nicole, do you have any estimate on how long new business might take?
That's just an open discussion, so.
Okay, let's take a real quick break, about 5 or 10. We will call our meeting back to order. Under new business, appraiser issues to be discussed, and we just open this to the floor.
Yes, sir.
Okay, apparently we have some people who wish to speak, and the first speaker can just start. Go ahead.
My name's Wells Eady, and I'm the current president of TREAC. And we've been contacted several times by different appraisers, agents.
What organization was that?
Tennessee Appraiser Coalition.
Okay, thank you.
And we've been contacted on numerous occasions by different appraisers, agents, and individuals to kind of open the discussion on something I think y'all touched on maybe in the March or April meeting, which is the customary and reasonable fees. And right now, I think that the current structure we have, or lack of, does not really promote the public trust or technology, geographical competency. And I wanted to come and, because there's so many different possible scenarios, just kind of get the direction of some better minds and see if TAC can assist the board in any way of kind of getting the ball rolling on any of this. We've been watching closely the Virginia and Georgia boards, how they've proposed theirs and what they've done. I included a Georgia kind of synopsis of what they have going on in their state. I don't know if y'all have that. I can give it to you if you don't. And then also we've been watching Virginia, and Georgia did an individual fee study. They paid for, I think, the University of Georgia to do it for them. And Virginia they adopted the Veterans Affairs schedule as a minimum. I know the wording of the Veterans Affairs says, I guess that establishes their maximum, but Virginia said it was the minimum. I think it's only been in effect for maybe about 3 months now, so I don't know if it's really a good thing or a bad thing. But anyway, I just kind of like to throw those two ideas out there, get y'all's thoughts on it, and if that's the direction we'd like to go, I'd like to see if y'all could I believe y'all have to put out a bid for maybe a fee study, and it needs to be done by the state. The other option, which I've read about, and I don't know any states that have done it, but it would be to propose a maximum, profit of the appraisal fee that AMCs could could charge and as a percentage. So just, making up a number, you would set it at something as like 20%. So if it's a $400 appraisal fee, they could only make a maximum of, say, 80% above it. And I see that as maybe a viable way to go, because I think that would, I don't want to say put the AMCs on the appraiser's side, but it would kind of align us together, where an increase in fee would not only promote like possibly the better appraisal, but it would also promote both sides increasing fees. I think as it would allow for the scope of the appraisals to increase as well. And I think management companies, if they're the right ones, actually do a huge service for appraisers. I know they have to review the work, and so as the appraiser's scope would increase, so would the management company's review scope, and as the appraiser would get more money, so would the management company. I think it would kind of slide down the line like it should be, and promote higher fees. So I just kind of wanted to throw those two ideas out there, get y'all's thoughts on them, and see if TAC can assist y'all doing any of the dirty work in any way, assembling information, proposing some legislation, and possibly seeing if y'all can put, is it called an RFP? Is that the bid, an RFP out, maybe to obtain a fee study for the state?
Let me just ask a quick question while I'm thinking about it. I think Virginia and Georgia, you made comment to. Louisiana also has in effect too, don't they?
Several states have. The reason I keep referring to Georgia is I'm in Chattanooga, and
Sure.
so I practice in
Sure.
Georgia and Tennessee.
Sure.
My uncle's actually on the Georgia board, so I'm most familiar with that. I have talked to Virginia, and they had told me how they did the VA fee, and said basically, like, we don't know yet. We don't know if it's a right or wrong thing. We tried this one.
Right.
And I think their thinking was the way Georgia did it, they got a fee schedule. I mean, a study done and established the customary and reasonable fees. Well, that doesn't update unless you have it updated. You're continually paying for it.
Right.
Virginia was thinking, hey, the government updates the VA fee panel every 3 or 5 years, whatever it is, and at least it's going to adjust on its own. And so we're not like locking in fees, and then it's the burden's on the state to keep updating them all the time. And they said we also changed the wording and established that as a minimum, not a maximum, because I believe VA's wording on their fee says, hey, the maximum fee we're going to pay is this amount. So
Virginia's used that and said the minimum.
Virginia did a study through Virginia Tech.
about 3 years
Yeah.
ago, and I think when everything was said and done, they had just decided it was too old when they got the ball rolling on this. Like I said, I think they just got theirs implemented maybe 3 years ago or so.
Certified in Virginia. I got my letter Friday about it.
Sure.
I have a question. I can understand there might be some advantages for the appraisers in this, but the purpose of this commission, or part of the purpose of this commission, is to protect the consumer. What is the advantage to the consumer of what you're proposing?
I think I know there's an AMC member here, and I respect a lot of the AMCs. I work for several of them, and the ones I work for are fantastic. But there are some AMCs out there that they're concerned about two things. It's about who can do it the quickest and who can do it the cheapest. And I think from what I've seen and what I've heard, that is creating a situation where people are cutting costs because they're doing $200, $250 appraisals. They're cutting costs by cutting data, services, quality, the things that are needed to go into an appraisal. I looked at one the other day. I'm not going to comment on the work of another appraiser. It was a real estate agent who said, I have absolutely lost trust in y'all's profession because of this appraisal that was done. I want you to look at it. The guy didn't have any reference to our local MLS service, and he had come from quite a distance away. It actually was a doctor in town that I know, and she was kind of in the same light as the real estate agent and saying, y'all's profession is going down the drain pretty quick. And I said, look, this was a bad management company. They hired somebody really far away, probably paid him pennies on the dollar to come do this. And so I think it's really hurting the public trust. And I think something like this would incentivize the AMCs to select the better appraisers. And the good AMCs, like the ones I talked about that I work for, this isn't going to impact them at all. They're already doing it right. So I think if we set something in place, this is going to clean up the AMCs that are offering those, $150, $200 for full 1004 jobs.
So the benefit to the consumer would be the improvement in the quality of the service. Thank you.
In addition to, I am the AMC member, by the way. In addition to Dr. McCarroll, his concern of the public trust, wouldn't it also be in the best interest of the public trust that if appraisers see this type of action going on among AMCs, they should be turning those AMCs in to this commission so that we can review those and we can fine, penalize, revoke, whatever we need to do as a commission in the best interest of the public.
Yes, and I mean, oftentimes you hear about it, but you don't actually see the appraisal. You're not given all the information. You usually have a real estate agent or consumer come to you and say, you know, here's the situation. Of course, there's always two sides to it, but I mean, I get it weekly. Here's the situation. Oh, I just want to be done with it. I don't want to, you know, have you do a review and submit to the state and all that. And so,
At that point, it's the public taking their own matters into their own hands, and they
It
can't do
is.
anything about it. But if they'll, you know, that's where we need to educate the public and say, if you have a problem against this AMC, Mr. and Miss Appraiser, or Mr. and Miss Realtor, or Mr. and Miss Individual, turn them in to the state board, to the state commission, so that we can properly penalize. Also, I have a question in regards to the fee study, just in case everyone else is not familiar with this or what's going on, but that's only going to apply, customary and reasonable fees only applies to AMCs. It does not apply to individual banks to that extent. So my question in that is, if we want to get involved in doing a fee study or send something out for an RFP or something to that extent, it's only going to have an impact on the AMCs. It's not going to impact individual banks. And as you said, you do work with a lot of the AMCs that are good AMCs, that do pay fair and everything to that extent. Well, in that situation, if you're working with individual banks who are not paying customary and reasonable fees, this won't have any impact on them whatsoever.
right, and you know, I might just be lucky. Maybe I'm not representative of all the appraisers out there, but I work with quite a few banks, and they all seem to pay at or above what our normal market price is, and they're easy to go to and negotiate if the scope increases. So,
Well, I would definitely like to say that if you're getting bids or assignment possibilities and you're turning them down because of the low fees, maybe you need to bring that up to the commission as to who those AMCs are. Absolutely.
is there anything with teeth in it right now that says that they have to be paying the reasonable and customary fees for Tennessee? I don't
think we have anything.
That's kind of where
Other
I'm.
than Dodd-Frank.
You mean what's
Which is,
coming
well, it's
up?
going to be imposed in 2017.
Mr. Chair, if I might just add to the discussion. The federal recommended language for regulating AMCs just came out this last fall. So we've got that, and Sarah has drafted a proposal for to send to the governor's office so that we would be in compliance with the requirements such that AMCs could be on the national registry if they choose to in Tennessee. Our current statutes didn't have reference to the Truth in Lending Act. That didn't mean it's not enforceable, because that's a federal law, Truth in Lending. But in order for it to be affected, pretty much it would have to be a class action and filed with the Attorney General's office. Generally speaking, a group, it could be just one, but if you're going to get the Attorney General's office in, it pretty much has to be a pretty big case. So if there was an appraisal management company that was abusing a group of appraisers, the Consumer Financial Protection Bureau would take action against it. They investigate those complaints currently, and they work with the Attorney General's office in each state in order to prosecute their cases. To my knowledge, no cases have been brought to Tennessee by the Consumer Financial Protection Bureau, nor have any been submitted as complaints to my office. Before AMCs got licensed, there were a lot of people anecdotally calling and complaining about AMCs, but since 2011, we've had almost no complaints against AMCs. When their complaints are filed, it has nothing to do with fees. It's more generally, I got kicked off the panel, or I wasn't paid within 60 days. And like I said, they're very few. I think if we added them all up in the 5 years, maybe 20 cases, maybe ballpark. That's not a lot. Not even.
All right. Anything else, Mr. Eddy?
That is a lot of hoops to jump through, and a lot of people, I think, are unaware that that process even exists. And so I'd like to get does have teeth, and that the appraiser and the consumers can look at, and as part of what I'd like to propose to you guys and draw up, provided y'all would let us, would be something that also on the appraisal report separated the management fee from the appraisal fee, so that the consumer can also see exactly where their money is going.
It's supposed to be identified now, is that not correct?
It works the opposite way. The appraiser can't be prohibited from reporting their fee. The AMC does not have to put that information. They could put it on the HUD 1 as whatever, but if the
Not a
appraiser
HUD.
wants to include their invoice, they can.
Ain't no more HUD ones. Okay. Well, the only thing I can tell you at this point is we'll let the commission chew on this and see what's going on. I'm all in favor of raising appraisal fees. I mean, that's what I do for a living, so,
Can I make one
I
more
don't,
point?
yeah, I don't know if, sure, go ahead.
The other, let's give a little scenario here right now. Let's set it in modern times, because, up until January 1st of this year, typical fees on a 1004 URA or statewide were probably, give or take, somewhere around $375 prior to January 1 of this year. After January 1 of this year, and talking with appraisers around the entire state, and I talked to them from this part of Memphis to this part of Johnson City and all cities in between. I know of appraisers now who, in subdivision appraisal reports, we're not talking about a 20,000 square foot house on 72 acres. This is a 3,000 square foot house in a subdivision. I know of appraisers who are charging fees of anywhere from $450 to $800, ranging in turn times of anywhere from 1 week to 3 weeks, and they're getting those bids. So,
Conventionals.
yes. So, in regards to this study that you're proposing, if we go back in and we discuss customary and reasonable fees, and if customary and reasonable fees are based on historical data, which is what you would be basing it on, depending on how far back we go in history, let's say we set the customary and reasonable fee at $400. Now, all of a sudden, it has been defined statewide, customary and reasonable fee is $400. Do you think that appraiser who's getting $800 or $700 or $600 is going to be happy to find out that the customary and reasonable fee is $400, or do you think they're going to be a little upset because they just lost half of what they could have charged based on supply and demand in the current market?
I do believe that that's a
Excuse me,
case-by-case
would you
basis.
introduce yourself?
Creighton Cross, also Vice President of Tennessee Appraisal Coalition from Knoxville, Tennessee. I've seen the same thing. We work with a lot of AMCs, and we are getting a select group of really qualified groups, as well as banks, that are paying full appraisal fees above the numbers you just mentioned.
Right.
But what we're also seeing is a significant amount of bids coming through. There's 225, 275, 250. And what we're asking is for the commission and the state to look into setting the precedence of minimum appraisal fees in which everybody is accommodated by. And that doesn't mean that I may still be able to get my $600 and $700 fees on my specific properties. I don't see that changing. Obviously, that's a sign of the times, supply and demand and things of that nature. But we at least do set that precedent so we don't fall back into a dip where everybody's charging $275 and there's somebody out there taking it.
Are you suggesting that we establish a price floor?
A minimum.
Yes.
Yes, a minimum.
Does that not define price fixing to?
In other states, no.
I also, kind of on an unrelated topic, thought about this, and the state of Tennessee just allowed wine in the grocery stores in Chattanooga. And I thought that was interesting. And I went over to the package store that was next to it, and I said, is this crushing your business? Just interviewing the lady. And I actually called one of my friends that works at a distributorship to confirm what she's about to tell me. And she said that the state had issued a premium that the grocery stores have to charge, which would be the same as establishing a floor.
Minimum fee.
Well,
And this
that's what we're going to be
protects-
starting to pay per appraiser starting in 2017 for AMCs. They're going to have to start paying a fee for every appraiser that's on their panel. Every appraiser on their panel in every
We're talking
state.
about the $25 appraiser.
Yes.
And I would like to, when we're going through this, make sure that that fee does not get passed down to the appraiser or the consumer as well.
From the point of view of an economist, the history of setting price floors and price ceilings to benefit consumers is not a very attractive history. And he usually ends up benefiting someone other than the consumer. So I'm going to have to be convinced that there's going to be a net benefit from
I
this.
just feel like the AMCs are kind of making appraisers like Uber cab drivers right now, and that is what I want to prevent. And the main reason is to protect the public, because I see appraisers cutting technology. I run that CompFlow database, and I've had appraisers call me and say, hey, I'm going to have to drop. And I'm like, this is appraiser data in our region. Why are you dropping? Well, because I just, I'm accepting these lower fee jobs, and I just, I can't afford it. It's just one more thing.
And that is why you should say to that appraiser, quit accepting that fee. That is how you set the point to those AMCs. When the AMC can't find an appraiser, then what do they have to do at that point? Exactly.
That
Go up on
works
the fee.
great when it's busy, but when times are slow and you're eating mac and cheese and you've got 2 kids to feed, you're going to get to the point where you accept a job for $250 just to get some money in.
I'll just Rex.
Well, one thing too that you mentioned was geographic. I'm going through a refinance on my house, and I pulled the refi because the AMC was sending an appraiser from Southwest Virginia that I'd never heard from, and he was traveling well over probably 50 or 60 miles and didn't know where I was. Couldn't find my house, asking all different kinds of questions. So, as far as the guidelines, setting the parameters of geographic competency would be
I agree. Geographic competency should be one of your one of your first priorities that you look into. But again, that's where that AMC company needs to be turned in to Virginia State Board.
And there's also one thing to think about, which is maybe some appraisers that have been removed from several lenders' lists because of poor appraisals. That might also be incentive for those appraisers to accept lower fee jobs because it's all they can get.
Right.
So
Just to put the point before we ask this gentleman to speak, let me just ask you a question in case you know the answer. In your reference to an independent fee study, do you have any idea how much that might cost?
I've heard between $10,000 and $30,000.
Right.
And to Louisiana's bill that they passed, I actually have a copy of that along with some notes on that. Geographic competency was one of the biggest things that went through that element. The AMC panel was interviewed. There was a governmental study that was done, and an independent college was also paid to do studies. All three came together with very similar numbers, including appraisers with bank fees, the VA panel. There were a number of different conclusions.
Did they poll the AMCs?
To my knowledge, based on this document, yes.
I know Georgia did not.
Do you think, considering the fact that the AMCs are the ones who are going to be under the customary and reasonable fees, the AMCs should be polled for that?
I do, and I also think there should be legislation designed so that there's banking regulation involved in that. There should be, it should apply to all parties.
You're saying it should apply to individual banks
I believe
and
so.
not just AMCs?
The appraisal fee should be
Universal.
universal across the board.
Okay.
And that's based on, and I'm not an attorney, but based on what I've read in the Louisiana and sitting on the regional meeting with one of the commission members from Louisiana and talking to them, that appears to be what they were trying to accomplish in Louisiana.
Okay, hang on. You wanted something to say?
My name is Jason Bennett. I'm the owner of Clarity Appraisal Management.
Yes, sir.
To their point, I completely understand where the appraiser stands as far as, getting a fair fee for doing the work that they're engaged to do. Some of the things that, have been brought up that, I feel like we pay a customary and reasonable fee. A lot of that is market driven. The fees, as Mr. Collinsworth had said, have gone up rapidly this year. One of the issues that you all don't have to experience, that we do have to experience, is TREAC. That's new regulation where the appraisal fee is no longer can be changed after it's been disclosed, unless there is a circumstance in which you can prove that, it was a duplex, but you ordered as a single family, something, it was a commercial, you ordered as a residential, then you can redisclose. So the banks and the mortgage companies, after they've disclosed the fee, they can't redisclose the fee because you guys said it's more complex. So what we specifically do at Clarity is we pay the fee. We pay the difference in the fee. So if, they disclose $445 and the appraiser said, I need $500 to do it, I pay him $500 and I eat the difference. Because the banks, either they're going to have to pay it themselves, or they say, go find another appraiser who will do it for cheaper. So that's one of the issues that we're specifically running into right now. I've read the Georgia bill as well. I've looked at the Georgia fee schedule. The one thing in the Georgia fee schedule that I was a little confused by is, in some areas, what the appraisers said they were paid was more than what the banks said they were paying. So to the point of polling AMCs like was discussed, well, the CFPB, it specifically says in there, you can't poll AMCs for fees. They have to be excluded. So who's verifying the information? We're just taking people's word at it. That's what happened in Louisiana. We do business in Louisiana. We do business in about 28 states. Louisiana has some extreme, probably the toughest other than Minnesota in the country, license, rules against AMCs. I'm looking at it as a business owner too. I'm not, asking the commission, to take my side over this, but we are very much market-based pricing. As the market changes, our fees go up and go down. We've had to increase fees repeatedly. But when, things start to slow up, we all know they will eventually. We're booming right now. Everybody's booming. And we're saying we have to pay a minimum of $400, whatever that number is. And, I hear a lot, geographical competency is important. But I hear a lot of appraisers going after other appraisers because they're not competent to complete the assignment, or they're, they're a chippy appraiser. They'll go out and they'll do it for $225. I have a problem with that because the board is saying these people are qualified to do appraisals. And if you are saying they're qualified to do appraisals, their business model says I can accept an assignment for $250. Isn't that up to them?
That therefore is almost setting customary and reasonable fees the low end right there. If you've got an appraiser that says, I'll do it for $225, do you not have a peer who's saying, I'll do it for $225?
And I just want to make sure that it's absolutely clear. And the current statute and the one that would be proposed for the future, both of them include geographic competency requirements for the AMCs when it's necessary for them to engage an appraiser. And of course, the appraisers already had a geographic competency when it's necessary for developing an opinion of value. So all of that's already incorporated in the requirements for appraisers, competency and on both sides. So if there is an issue, like if there were potentially an AMC that was abusing it, like, oh, I'm going to use all my guys from one specific spot, and they're going to just go out and do the whole state, even though they don't know how to handle all markets. If that was a pattern that we could detect as a administrative office, we would put it forward to the commission as a complaint if there was an outcry or whatever. So there is a mechanism that is in place. And the last thing I want to say is I strongly, you guys obviously have all the power to make the decisions on these kind of things, but I strongly recommend you take a very careful and measured approach on this. The states that have rushed in full throttle have regretted some of the things they've done. And certainly, you know, by being one of the first couple states to implement, you get to see the mistakes come to light thereafter. There is a mechanism in place for appraisers to complain. It's posted on our website for customary and reasonable fees. We have a link under the frequently asked questions. We have one under consumer resources. And of course, we have links to the CFPB. And of course, if you file directly with our office, we can turn it into the Attorney General's office ourselves. But even though we don't have specific authority to enforce truth in lending, all of the subcomponents of it we do, like geographic competency and that sort of thing. So fee studies are really great, and I know that the commission is strongly considering having one done. They're expensive and they expire. Once you get them, they're good for the day that they're completed, and then the market changes, and that's not customary and reasonable fee anymore. And I've always been very hesitant for advising anyone on the board to get in the business of starting to set appraisal fees or AMC fees. It goes contrary to the core mission of protecting the public, in my opinion, and it harms as many as it helps. So, yes, there is potential that there are appraisers out there doing less than adequate work. That's part of what's the commission's responsibility to regulate. It is possible that some AMCs are less than scrupulous in engaging appraisers. Again, that's under your authority. But telling everybody that they have to, at minimum, pay $400 may run some very good companies out of business. It may encourage others to reduce what they were paying very good appraisers. And it also gives the commission an appearance of bias, in my opinion, if you start getting in the business of setting fees.
Thank you, Ms. Evers. Gentleman in the back, you have anything to add? Okay.
He's a trainee.
Anybody else have anything else to add? Go ahead, Mr. Cross.
If I may, I would also like to bring to the board some thoughts on statute of limitations on appraiser liability. We've heard, over the years, different cases and different situations where appraisers have retired or an appraiser is no longer practicing and they are still brought up on charges within 3, 5, 6, 7, 10 years even. Did a little bit of research on the statute of repose in the state of Tennessee and repose as far as statute of limitations on having a case brought against you. Obviously, in the state of Tennessee, according to Peter Christensen at LIA Administrators, we have a discovery rule, and it's my understanding that that's a 3-year window from the time of the action, based on what I've read, and so that's one statute of limitations that we have. But looking back through a few other professions, in particular, state of Tennessee construction law, architects, the American Institute of Architects, they have set some other standards as far as liability claims against their professionals. And I just wanted the commission and the state to look into potentially limiting that time frame, even more than that. Case in point, we have an appraiser who retired, and say an appraisal comes up after he or she has retired, and they're sued for that. You know, and as an owner of that company, I carried the liability policy on that appraiser. It's a business model. And I think that there needs to be some clarification possibly. I don't know if that's from the states or the Attorney General, but somebody needs to address that, because it appears that appraisers are not being benefited from protection in that capacity. Along with that same standard, there's some thought and some appraisers out there that would like to see some type of statute limiting the amount of time in which the appraiser may be brought up on charges at the state commission. Case in point, where we have an appraiser that may have retired, all of a sudden, you know, sitting at the beach in Florida doing whatever they're doing, and they get a state commission complaint, even though they're not a practicing appraiser. Obviously, they have work file retention for 5 years per use PAP minimum, you know, so we have that. But just a thought, something for discussion as far as, you know, benefiting the appraisers. I am working on behalf of the appraisers here. I want our appraisers to be protected in that regard.
Just so that everyone knows before you discuss it, it is not under the commission's statutory authority to set statutes of limitations. That's not part of what you have an authority over. We have that 5-year requirement for record keeping, but beyond that, there's nothing in our statute that would allow you to set a statute of limitations. In fact, most of what you were talking about sounded like civil lawsuits, and that is outside of licensing law. So I just want to make sure that I'm glad for you all to discuss it, but that would be a legislative change, not you could change it by rule or something.
I was reading the Whaley versus Perkins 2006. That was the determination and cause of action was determined at a state level. Is that not in their commission? That was for architects.
It can be at the state level, but it's state legislator level, not necessarily at the
Okay.
board level. The board can't make.
The board doesn't make any recommendation or anything from that.
It can make a recommendation to the governor's office potentially, but
It would have to go through legislative proposal is what she's saying. So we would have to
Lobby.
propose it, and then we would have to back it, and we'd have to have, you know, the support of the department.
That's not the people in this room.
No.
No.
Would that include complaints?
They could make it for complaints. I mean, obviously, even if you went to the governor's office and said, we want to propose this, you don't have the authority to bar civil lawsuits. That's under civil law. You could say, we could propose, you know, a 5-year statute, you know, and it would have to go through the governor's office, and that would be for complaints.
Filed with the state commission.
Yeah.
Okay.
And I don't know of any other boards or commissions, and I mean, Nicole has the gamut, that have statutes barring. I mean, just because someone's retired doesn't mean that we shouldn't be able to file a complaint against them. Otherwise, we would have that happening all the time.
Situation with previous recession, 05, 06, 07, appraisers that say the firm has never met. Those people have been out of the business for a number of years, and a complaint comes up 10 years later, and we don't have a work file. We still have to spend time and money and resources to explain that on the state level.
Right.
There
Do
needs
it-
to be some type of
May I?
stop. Yeah.
all right, if it's okay that I speak. I have experienced an awful lot of complaints in 10 years. I didn't think I'd be going back through the history on this Old Timers Week, but we have had many cases in 10 years, thousands, and almost never do they come back if they're over 6 years old. That's like an exceptionally old complaint. The state, if you want to look at it this way, the state has the burden to prove that the appraiser did something wrong. The appraiser has no burden to prove anything. They have to, if it's within that 5-year window, they have to give their work file, really, and that's it. There isn't even a rule that says that they have to respond to the complaint other than give us the work file. although the commission may take a pretty dim view of never responding to the complaint. So the burden is on the state to prove that an appraiser has done something wrong. Now, if it's 6 years old or 7 years old, it's going to become hugely more difficult for our attorneys to prove that an appraiser violated professional standards or a specific law or rule. However, if it's so egregious that it can be proven, let's say it was a case of significant mortgage fraud, and the only reason we didn't see it is because it was tangled up in foreclosures and whatnot, and then all at once the bank dropped 20 appraisals on our laps that an appraiser participated in a mortgage fraud scheme. The complaint is now 6 years old. Does the commission give the guy a pass for participating in mortgage fraud, even if we could prove it because of a statute of limitations? Commission always has the ability to dismiss a complaint if they think it's not worthy, not significant, if it's too old. Each case is handled on a case-by-case basis, and there have been times where the commission went, this file was a 2001 file, and we just don't think that the appraiser needs to be disciplined for that, and they just close it. It's neither proven nor disproven. It's just, we don't have enough here. It's not worth our action. And that's always within the commission's authority. If we set a statute of limitations, it will be removing authority from the commission and taking action potentially on a very serious case. And there are reasons why things sometimes take a long time to get to this office, specifically when they're tangled up and things like that.
I think one of the things that you may be talking about is there's a company out of California that's going around buying up bankruptcies from different lenders, and they're going back 10, 12 years and suing appraisers. That company is suing appraisers because they know appraisers, quote, are insured, and they're saying, instead of we're going to sue you for $50,000, but if you give us 10, we'll close the deal. So I think that's part of what but I don't think this is something that this commission at this point in time needs to discuss, because realistically what you're talking about is a legislative matter.
Thank you for clarification.
Anybody else?
If I could, just two last things. One was, I didn't really address the cost plus for AMCs to appraisers, say 20%. I think that may be looked at as potentially price fixing.
I think that's restraint of trade. I think that, I don't think you can do that at all. I think that's restraint of trade.
And on the last thing that they were discussing was, I know Texas just did a legislative update that made 24 months for their appraisers. The offense would have to be brought up within 24 months for the board to take action. They did that, I think, about 6 months ago. It was the beginning of the year. I do believe, though, if it were a case like Nicole said, where there was a civil issue after the fact, obviously that would not be covered. But the board could act after the fact, could they not, and revoke someone's license because there was, they got found guilty of fraud
Civil basis.
on a civil basis, which may cover kind of both sides of that argument. I know it's not.
I mean, if they were
Almost have to be
convicted of fraud and then it was turned into our office and they didn't disclose it themselves, then the board has the authority to look into that.
Every renewal period would also indicate that.
If they get convicted of a felony of any type, the commission can obviously consider that. And I've participated in cases with the FBI and the U.S. District Attorney. Where, again, it takes them a very long time to put their cases together against the mortgage companies and the appraisers and all the people involved in the cases. And by the time that they're willing to share information, years may have passed. And those are the exact cases that we need to protect the public from. I mean, those cases that are so egregious. I just wouldn't want to say, okay, 5 years is it? Okay, 6 years is it? Where is it? Where's the absolute limit? I don't know. To me, it's when it makes stops making your skin crawl, thinking of what they've done to these consumers or these banks and harm the public. when that becomes irrelevant, that's your limitation, to me. And I don't get a vote, and this is my last week, so whatever you guys want to do.
I don't have a problem pulling what Texas did just to get some more background for the
You
commission.
bring that to us at the next commission meeting?
Absolutely.
Okay. Anyone else? Next thing on the agenda is a motion to adjourn.
So moved.
We have a motion and a second. All those in favor, leave.
Say aye.
Aye.
12 o'clock.